The idea of preserving self-incrimination dates back to the time of the Puritans, who fled from persecution from Charles I of England. This persecution came in the form of ex officio. This was a form of judicial interrogation on mere suspicion, in which persons were prosecuted on information not given while under oath or achieved through trickery. This idea was incorporated into such legislation as the Massachusetts Body of Liberties in 1641, the Connecticut Code of 1650, and the Virginia Bill of Rights in 1776. These provided that no defendant can be compelled to give witness against himself. These ideas were also later included in the Constitution of the United States, which outlines the court system as we know it today, in which criminals are innocent until proven guilty, and the burden of proof is on the prosecution. Our forefathers include this idea in an attempt to make us more decent and civilized. In this film, we will present a number of Supreme Court cases and decisions which have formed the Fifth Amendment. Brown versus Mississippi. On March 30th, 1934, 3 men were arrested for the murder of Raymond Stewart. Testimony indicated that police officers administered brutal whippings to all 3 men until they confessed to the crime. Then they were told that if they... Do you mind? Then they were told that if they were changed their story at any time, additional beatings would be given. After their arraignment, the court appointed legal counsel. The preceding day, the case went to court. It lasted for 2 days. Now for the reenactment of Brown versus Mississippi.
I didn't even know the guy. It's all right, I don't want to hear it. You don't need to talk to me. He was my next door neighbor. You just moved in a month ago. I didn't even know him. Fine. I wish you'd quit bothering me, man. I didn't do anything. Let's just get in the room right here. Listen, man, I don't want to go in there. Go in the room. What is all this for? Don't worry about that stuff. I don't want to go in there. Let's get in the room. Man, what is all this? What is all this stuff? It's just here for looks. Don't worry about it. God. Man, I want to know what this stuff is for. You'll find out in a little while. Don't worry about it. I want to know what this stuff's for. It's okay. It's just going to be in here. You don't need to worry about it. God. Hey, you guys aren't planning on physically abusing him, are you? Nah. All right, you murderer. We know you did it. We gave you a chance. Now you won't have to confess. This on here. Oh, I can't wait. I guess you're ready to sign now.
Well, yeah, I guess. I sure hope this will work.
Don't worry about it.
Just sign.
That's it.
No, we like your motion.
I think you're right.
You may be seated. This time, court will come to order. Will the prosecution at this time present its case?
Yes, Your Honor. At this time, I would like to call to the stand the interrogating officer.
Place your left hand on the Bible. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may take the stand.
Would you state your position on the police force? I'm the deputy sheriff. Were you the interrogating officer for the defendant, Mr. Brown? Yes, sir, I did. Did you receive his confession? Yes, sir, I did. Your Honor, at this time I would like to present to the court the signed confession of the defendant. This should be substantial evidence to prove the guilt of the defendant.
At this time, the defense may cross-examine the witness.
Thank you, Your Honor. So, you're the officer who received the confession.
That is correct.
How was this confession achieved?
Through voluntary means.
So, during the course of the interrogation, you did not in any way strike Mr. Brown.
Not too much for a Negro.
Your Honor, I would at this time like to call the defendant, Mr. Brown, to the stand.
You may do so.
Thank you.
Place your left hand on the Bible. Raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may take the stand.
Your Honor, after the confession. Mr. Brown, would you look at this? Have you ever seen that before?
Yes, I have.
Is that your signature on there?
Yes, it is.
Tell me, were you forced in any way to sign that?
Yes, sir. I was tortured until I signed the confession.
Your Honor, seeing how this confession brought about by torture, and since it's such a mockery of justice, my client cannot be found guilty.
That may be true, however, since I have a signed confession from your client, I must find the defendant guilty as charged. I hereby sentence the defendant to death. That's fine.
Mr. Brown appealed to the Mississippi Supreme Court. The conviction was upheld. He then took his appeal to the United States Supreme Court. During the hearing, the state of Mississippi stated that involuntary self-incrimination did not apply to the state in state cases. However, the U.S. Supreme Court stated that this was not what was being questioned. The court stated that the appeal should be based on the fact that torture had been used to gain the confession. Chief Justice Charles Evans Hughes further stated that the use of torture to extort a confession was revolting to the sense of justice, and that it constituted a denial of due process, which was the right a state could not withdraw. The court reversed the conviction on the basis of this fact. Spano versus New York. In the case you're about to view, Spano versus New York, the defendant Spano was charged with murder. After being arrested, he was questioned for 8 continuous hours by a team of officers. One of the officers happened to be a childhood friend of Spano's who had gained his sympathy by falsely stating that his job would be lost if he did not cooperate and confess. The interrogators continued their questioning for a confession. Despite Spano's refusal to answer, on the advice of his lawyer, who had personally surrendered his client to the police. Now to get this case rolling.
Could you hand me that, please?
Yeah.
Thanks, dude. Oh, man. Thanks.
Here's a reenactment of Spano versus New York.
Hey, Spano, how's it going? What are you doing here?
Okay, sit down. Yeah, right there. Okay, you sit there. Don't move. I'll be right back. Hey, wait a minute. Hey, do you know that guy in there?
Yeah, I know him. We grew up together. We had the best stickball team in our neighborhood. I remember one time when we were...
Never mind about that. Do you think you could go in there and get that confession from him so I don't have to do it?
A confession? What for? What's he done?
Okay, brought in on a murder charge, and I've got interrogated. I hate interrogation.
Spano was brought in on a murder charge?
Yeah.
I don't believe that.
Well, I believe it. Judge probably won't. That's the reason you gotta go in there, spend all that time getting that interrogation. You could go in there and get it like that. Do you think you could do it?
I don't think I could do that now. That's my best friend sitting in there. I can't do that to him.
Well, okay, never mind. Thanks anyway.
Hey, where have you been? I've been looking everywhere for you.
I've been talking to that rookie. He's that murderer's best friend in there. Do you think I tried to get him to go in there and get that confession? He won't do it.
That new rookie over there?
Yeah?
I thought you could usually get rookies to do anything, you know?
Yeah, I know. We have before.
Well, don't worry about it. We gotta get in there and get that confession.
Oh, okay.
What's your name? Mark Spano.
Where do you live?
1392 41st Street, New York.
Where were you on the night of the murder?
I was at a party.
What was your relationship with the deceased?
I just met the guy. He's a friend, I guess. I don't know. I guess he's just a friend.
But isn't it true that you had deep-seated hate for him?
No! Why don't y'all just leave me alone? You've been questioning me all night. I'm sick of it.
All the evidence points to you. That's right.
Now quit trying to frame me. What is this?
Look, we're not getting anywhere with this guy.
Yeah, I know.
Look, you stay here.
Well, we'll have to get that rookie. The rookie that knows him.
Oh, okay, what's he done to it, though? He said he wasn't going to.
Give him a good reason. Tell him he's going to be fired if he doesn't get here and get this guy to sign that confession.
Okay,
You can
I'll
do
try.
it.
Hey, wait a minute. You gotta go in there and get that guy to confess.
I told
Got
you.
to.
I can't do it.
Listen, man, you're gonna be fired if you don't. Sarge told me. I know you don't want to be fired.
All right.
Good reason.
Do the best you can. Mark. Been juniors for a pretty good while, haven't they?
Yeah, well, a couple hours.
I'm sorry. Have you signed anything?
No,
Have you
I didn't
told-
do anything.
Well, have you told them anything?
No. Why should I? I'm not guilty of anything.
They think you are. They seem to think they've got enough evidence to convict you of a murder.
I didn't do anything. Why should I have to sign something when I didn't? I won't hear this.
Look, come on. There's not anything you can do about it. They think they've got you on a murder charge.
They don't have to keep me in here for this long.
You know why they've done it? Because
Why?
you won't cooperate with them.
I didn't do anything. They're going to try to get me signed this confession.
That's right. That's what they want you to do. Then they'll let you go.
I'm not going to sign this. I didn't do it.
Look, I know you didn't, but they don't know that. They don't know it. If you'd sign the confession, it'd make it that much easier.
I'm not going to sign it because I'm not guilty. I don't have to do anything.
I know it. If you just sign it. Look, if you don't sign this thing, you're not going to be the only one to lose out.
What do you mean?
They're going to fire me.
Nah.
They said they're going to fire me if I don't get you to cooperate with them.
Who said?
The sergeant. Now, I can't afford to lose my job. Look, my wife's having her 4 kids. I cannot lose my job.
They're not going to fire you.
Yes, they will. They're serious. They're trying to convict
Man,
me
you're
of murder.
just trying to play with my mind.
We've been friends for a long time.
I know that.
I wouldn't do that to you.
Well, what am I supposed to do? You want me to sign something I didn't do?
It'll make it that much easier. What if you get in there in court? What if you get in there and they do have evidence that says you do? If you sign that confession, they won't use any evidence against you. They'll just use your confession.
Man, I'm just really sick. I'll sign this thing. I'm sick of it. Y'all. Here.
Look, man, you're making me feel bad about this.
Just go on.
Did you get it? I got it. Good here. My name. It's pretty good for a rookie. Good job.
Whatever you say, I don't like it, okay?
Hey, this might be a promotion for him.
After being convicted, Spano appealed his case to the Supreme Court on the basis that he had been subjected to psychological torture. Thank you.
Sorry.
After being convicted, Spano appealed his case to the Supreme Court on the basis that he had been subjected to psychological torture. Chief Justice Earl Warren reversed the conviction, stating that the police should have obeyed the law while enforcing the law. The court also extended this ruling on coerced confessions to include confessions gained by psychological torture. Miranda versus Arizona. Possibly the most significant Supreme Court case dealing with self-incrimination was Miranda versus Arizona. On March 1st, 1963, Ernesto Miranda was arrested at his home and taken into custody to a Phoenix police station. There he was identified by the complaining witness, a female gas station attendant. He was then taken into an interrogation room of the Detective Bureau. There he was questioned by 2 police officers who were later... Go back to sleep. There he was questioned by 2 police officers who were later admitted at the trial that Miranda had not been advised that he had a right to have an attorney present. 2 hours later, the officers emerged with a written confession signed by Miranda. A typed paragraph stating that the confession was made voluntarily with the suspect's full knowledge and understanding of his legal rights was attached to the confession. At his trial, the written confession was admitted as evidence of the objection of his defense counsel. On this basis, that Miranda's constitutional rights were violated, Miranda was still found guilty of kidnapping and rape. Now here's a reenactment of the circumstances involved in the case of Miranda versus Arizona.
Senor,
Come on, shut up. Get in there. Sit down.
¿qué?
Sit down.
Sit down!
All right, she identified you. We know you did it.
¿Qué, señor?
Just, we know you did it. You're guilty.
No. No.
Shut up.
What quiere?
Maybe we should get an interpreter.
He's guilty. I know he is.
I know he is too, but maybe.
Well, he doesn't need it. He's just a stupid wetback.
No
right,
pretende,
right.
señor.
Why don't you just sign it? We know you're guilty. We know you're guilty. So confess.
Sabe bueno más que tú.
I don't like that.
Do you understand what that stupid wetback just said?
No, that's why I won't get an interpreter.
Don't worry about it. This guy ain't got no
No
right.
gente gringo.
Just shut up. Sign this thing.
How about a lawyer?
He doesn't need one.
He doesn't understand. Okay. Sign the paper.
Señor.
Sign the paper. Sign the paper.
Sí.
Stupid spec. Sign it. Hurry up. Give me that. Stupid spec.
I
I'm
know.
glad we finally got this confession.
Ain't that the truth? Let's get on.
Got a gringo?
I'm not tired of these still legal. You may be seated. Before we begin with this case, I'd like to have the defendant take his hat off. Court come to order, and this trial will begin. This time, I'd like to have the prosecution present its evidence.
Thank you, Your Honor. I would like, if it would please the court, I would like at this time to call Detective Kent from the Arizona State Police.
Place your left hand on the Bible, raise your right hand. Do you swear to tell the truth, the whole truth, and nothing but the truth, so help you God?
I do.
You may take the stand.
Detective, if you would, please state your full name and position on the police force.
Philip Edward Kent, detective.
Thank you. Could you tell us what your involvement in the case before the court today is?
I was the interrogating officer at the time when Mr. Miranda signed the confession.
And how was this confession arrived at?
It came about voluntarily after 2 hours of questioning, and he signed the confession.
Your Honor, I'd like to present before the court a confession from Ernesto Miranda, included with a paragraph stating that he fully understood, that he had his rights and what he was signing.
Okay. At this time, would the defendant like to cross-examine the witness?
Yes, Your Honor. Are you an understanding member of the police force?
Yes, sir, I am.
Okay. Did you read Mr. Miranda his rights before questioning?
Yes, sir. We do that every time.
Did you read them to him in Spanish?
No, sir, there was not anyone who spoke Spanish at the time.
Did he understand his rights?
As far as I know, he did.
One last question. Did he understand his right to counsel? Or to have an attorney, and to have an attorney present during interrogation?
Like I said before, as far as I know, he did.
Your Honor, due to the fact that the defendant understands very little English, I feel that he did not completely understand his right to counsel. Therefore, this confession should not be used as evidence.
This is not a proven fact that Mr. Miranda did not fully understand his rights. Therefore, I must find the defendant guilty as charged.
After being found guilty of rape and kidnapping, Miranda appealed to the Supreme Court. His appeal was based upon the fact that Miranda did not fully understand his right to have an attorney present during the interrogation. Also, from testimony of the officers, it is clear that Miranda was not in any way apprised of his right to counsel with an attorney, nor was his right not to be compelled to incriminate himself effectively protected in any other manner. Without these warnings, the court found that the statements were inadmissible. The court further stated that the mere fact that he signed a statement which contained a typed clause stating that he had full knowledge of his legal rights did not approach the knowingly and intelligent waiver required to relinquish his constitutional rights. Also from this case arose one of the most important decisions dealing with self-incrimination, the Miranda decision. The right of an accused person to have legal consultant present during interrogation and the right to remain silent, along with the right to be appointed an attorney by the court if the defendant cannot afford themselves.
During my many years as an employee of the government, I have gained a great deal of wisdom. I would like to leave you now with a few thoughts concerning self-incrimination. Unlike me, to the ignorant citizen, the Fifth Amendment right seems like a refuge for the guilty. On occasion, the Supreme Court has tried to correct this attitude. For instance, in 1956, the Supreme Court stated that in its opinion, the Fifth Amendment should not be thought of as a crutch for the guilty, but a constitutional right given to every American citizen. Of course, political freedom was the primary goal of the framers of the Constitution. But political freedom was one of the basic reasons behind the adoption of the Fifth Amendment. But an even more fundamental goal of the amendment, like the rest of the Bill of Rights, was to preserve and nourish that fragile and necessary quality that gives meaning and purpose to human life, individuality. We would like to also thank Mr. Judge Tillman for the use of his courtroom.
I'd also like to thank Security Officer Mr. Holly for his help.
Mr. Underwood also needs a note of appreciation.
My dad, and the film couldn't be done without the cameraman.
Also, my parents do need some credit here.
For the house
Yeah.
they gave up and was destroyed. It was lost.